Le cedo la palabra en primer lugar al embajador Trevor Clarke. Es ingeniero de profesión, ha dedicado más de 40 años a la gestión y a la ingeniería de telecomunicaciones, en especial en la empresa británica Cable & Wireless, en Barbados, donde ocupó diferentes puestos directivos. En 2004 finalizó su máster en Derecho, centrándose en los aspectos jurídicos relativos a Internet, la propiedad intelectual, el comercio electrónico y el comercio multilateral de servicios. En 2003 fue nombrado representante permanente ante las Naciones Unidas en Ginebra y representante especial ante la Organización Mundial de Comercio, con categoría de embajador. Tanto en la OMC como en la propia OMPI ha ocupado la presidencia de diferentes comités, entre los cuales me gustaría destacar el Comité de Desarrollo y Propiedad Intelectual, cuyo establecimiento él mismo impulsó. Señor Clarke, encantado de tenerle con nosotros. Puede comenzar.
Okay, good morning. It is really a pleasure for me to pay my first visit to Spain, my first visit to Madrid, and my first trip since I undertook this responsibility as an Assistant Director General in WIPO. So on behalf of the World Intellectual Property Organization, let me thank the National Library of Spain and the Ministry of Culture of Spain for your kind invitation to participate in and to learn from the extensive work that the European Union and others are doing in this critical area of digitalization of cultural material. I would wish to apologize for not being with you yesterday, and that's my loss. I arrived in the afternoon and had the pleasure of meeting with a number of performers and producers, representatives, NGOs. And the discussions with them was so interesting that I thought that with a little help from UCA, we could have had a diplomatic conference on this question of protection of audiovisual performances. Those organizations are very progressive and very interested in compromising their particular interests in order to see a solution to this long-standing issue. So I've started my visit with good news. My task today is to share with you some thoughts on the question of orphan works and out-of-print works, in particular the size of the problem. I will speak briefly on these four issues. Have a look at the numbers that are out there reflecting the size of the problem. Some causes of the problem, I'm sure I have not captured all. The range of difficulties, I should have used the word some there as well, because I'm sure that I have not captured all. But importantly, I would want to share with you WIPO's involvement in this issue. As you know, the problem of orphan works has become extremely acute with the increased efforts of libraries and similar institutions around the world to do a good thing, that is to preserve cultural material. Also with the availability of digital copying that has become so easy and with such complete quality. Also with the launch of large-scale digitalization of works for other reasons, other purposes, I should say, and the Google book issue comes to mind as another reason. I was with a group yesterday morning, and one gentleman made the point that even if the book settlement issue is not satisfactory in the United States, that the initiative that Google has taken is, again, another world-changing event. I think the word used was changing the game. That event, that intervention of Google is really going to change the game in this area of copyright. Of course, preceding that is the changing of the world. I think it is Bill Gates who made the point that the internet will change the world. So we are in a seriously changing situation with respect to copyright. The size of the problem is largely unclear. Some people will say unknown. I have found a British estimate of 40% of published works are orphaned, and the United States estimate, and this is not British government, and United States, not United States government. Let's say I've found an estimate on the web attributed to an American gentleman who estimated at the level of 25%. And to show you how difficult it is to estimate these things, this gentleman, whose name I wasn't able to find on the blog, but I have the reference if you need to follow up. He says his estimate is based on key facts from which he has extrapolated a conclusion, again reflecting the challenge in pinning down the size of the problem. And one of his assumptions is that the older the work, the more likely it is to be orphaned. And that's a reasonable assumption. But in his study, he looked at a record of over 2 million books published by US publishers between 1924 and 2000. And based on that examination, he has come up with this 25 to 29% of the work, the published work, being orphaned. There's also an opinion, which I believe is attributed to Bill Patry of the United States, which seems to suggest that the problem is not that big. What is big is the costs associated with identifying orphan works. So that's a way of saying it's not big, but it is big. Significantly, the 206 United States government report on orphan works, and I believe Maria Palanti will speak to this or correct me if I'm wrong. This report indicates that the problem is elusive to quantify and to describe comprehensively. So we are looking at a very challenging problem. Some causes of the problem. Now, I must tell you that I'm not a lawyer, so I am free to make practical and pragmatic statements. Now, that doesn't say that lawyers are not practical and pragmatic. It just means that the lawyer's pragmatism is different from mine. The Berne Convention in Article 5.2 says the enjoyment and exercise of these rights shall not be subject to any formality. And it is interesting how we can go through the formality of courts in order to preserve and protect those rights. But many of us are not prepared, not interested to go through the formality of registration as a means of protecting those rights. And that is an issue that I think needs to be more widely discussed. I know some countries, I read a lot of how the United States have gone about voluntary registration, but if you are to enjoy and exercise the rights without any formality, I think we need to understand and accept what minimum level of formality would work in our interests. It is clear that when the first Copyright Act in 1710 was drafted and when the Berne Convention was drafted, that our forefathers would not have anticipated the huge volume and range of copyrighted material, nor would they have anticipated the arrival of the digital world. These fundamental changes have really increased or brought about the problem with which we are confronted. Now, while the orphan works presents difficulties in all areas of copyright, some works like photography are particularly difficult. I read that photographs from World War I and World War II are prime examples of the severe difficulty orphan works present. Very interesting and informative photographs, difficulty in using them and sharing them with the public because the owners of those rights are not known. The chair of the Museum Copyright Group in the UK, Mr. Peter Wynard, he expressed the view that from a total collection of around 19 million photographs that he has examined in 70 institutions, sorry, I shouldn't say examined, I don't think he examined 19 million photographs. I think he found a way of assessing the state of ownership of those photographs. And he came up with a percentage, 10% of those photographs, which I thought was a significantly small number, 10%, but he came up with a 10% where the author, no, it's 10% is where the author is known. So it's 90% where the author is not known, if I got that correctly. But a greater difficulty lies in the large amount of unidentified content available on the internet. And we are aware that rights management information technology is available to help reduce those difficulties. And a good friend, relative of mine, Mr. Clarke, has left us with these words: the answer to the machine is in the machine. Now, it is my view that works that have not been commercially exploited or are no longer commercially exploited and hence may have gone out of print are more likely to lose trace of the rights of the owner along the way. So when we experience difficulties identifying the owner of the rights in these materials, where do we go? We go to government sources and we go to private sources. But the state of the game now still suggests that both government sources and private sources have their limitations. And there's a long way for us still to move to improve the situation. Digitization has contributed to worsening the problem. But as I referred earlier to Mr. Clarke, the good news is that digitization is also offering some solutions. But we have to be sure that what is in the machine is complete, it is standardized, and it is accurate. Otherwise, the answer to the machine may very well not be in the machine. Looking at the work being done by the ARROW project, the European Accessible Register of Rights in Orphan Works, we applaud that work, and we would like to encourage the international community to take the necessary steps to globalize this type of solution for orphan works. Clearly, the time for paper searches are over. Now, briefly, let me jump to this WIPO's involvement. As you know, the World Intellectual Property Organization administers the Berne Convention and other treaties associated with copyright. the convention which provides for national legislation to designate an authority to represent the author in case of unpublished work or of an unknown author who is presumed to be of that nationality. This procedure under Article 15.4 requires notification to the Director General of WIPO, who in turn will notify all other member states. I just quote that as an indication of WIPO's one area of involvement. The other area of involvement is in the Standing Committee. In discussing the agenda under the item Future Work in the Standing Committee on Copyright and Related Rights in November of 2008, the European Union proposed a discussion on orphan works, and they cited the problem that the cross-border effects of digitization is increasing, and we certainly need to look seriously at that. The European Union was supported by the United States. But of course, we do have issues in the Standing Committee to be resolved before we can have the capacity in the committee to move to these new, well, not new, but to move to these additional and challenging issues. I'm sure you're aware of the issues before the committee dealing with audiovisual performances, broadcasting, and the proposed treaty for the visually impaired, where I hope that member states can make some significant progress. This year, I'm new to the game, but I really am disappointed that something could be discussed for 14, 15 years, and we still cannot come to a solution. I'm tempted to say that maybe there's a lack of pragmatism in the negotiations, but I don't know. I am only hoping that enough is known about the problems that we can move to find solutions. Another area of WIPO's involvement is in the development agenda. Mr. Chairman, how many minutes do I have? 1, 2? Yeah.
¿Cuántos minutos tiene?
No, 5 more minutes.
5 minutes, good. In October 2007, the member states in WIPO adopted the 45 recommendations aimed at enhancing the development dimension of the organization's activities. Some recommendations were grouped in thematic projects, and one such project deals with intellectual property and the public domain. As you can see, combining recommendations 16 and 20 out of those 45, we have come up with 3 activities associated with this particular project. The next 4 slides speaks to these activities, and just briefly, there's a survey on voluntary registration and deposit systems with questions on orphan works, and I shall come back to that. There is a survey on private copyright documentation systems and practices, which, amongst other things, aim to discover what legislation or industry practices are aimed at identifying the owner of orphan works. And I should say, going back to this one, the survey on voluntary registration and deposit systems, that survey is still open. We hope to get some more responses by the end of April. So if any of you representing member states, please encourage the appropriate authority to give us the responses, because the responses do help us to better understand the challenges of orphan works. And finally, and I'm sure you'll be glad to hear of this project dealing with IP and the public domain, with its connection to orphan works will culminate in a conference at the end of next year where we will present the findings of these two surveys. The findings, of course, will be used by member states to determine what future course of action the organization should take. But let me make this key point, that the expectation of this work is that we hope that wherever we can solve the problem of orphan works, we will be able to, or we will be closer to knowing if that work is in the public domain. So even though the project is focusing on the public domain, there's a very important element in understanding which works are orphan as a means of understanding which works are in the public domain. So, finally, it is clear that the problem before us is really global in scope. And someone said that to me this morning on this floor. And it is also clear that despite the good work being done in Europe and the good work being done in the United States, the global problem will sometime require, or I should say eventually, require a global solution. And we would hope that the commitment of the European Union and others, including the United States, in addressing this issue will help to encourage other member states to get involved, so that when we resolve the issues currently in the Standing Committee, we can seriously put orphan works as a problem to be examined at the multilateral level in our future work. I thank you.